the only reason why I'm really even doing this or even getting into this analysis because Barnes challenged. Remember, he challenged us all. Read the documents, do the analysis, and I'm just going to say it. Nothing he said worked. The judge destroyed everything. Matter of fact, none of his arguments were even there. So I don't. Again, it's sad because I personally want to focus in on the legal part of this.
Yeah.
But I just think sometimes, our legal analysis isn't going to change based on who the person is. If it did, then it wouldn't be legal analysis. I'd be trying to push a narrative.
And the other thing that we both commented on, and I definitely believe this is still true, it's like once the state passed the motion to dismiss, we're going to trial.
Yeah, it's over.
Because there are no more preliminary moves here. There are no more intermediary steps. It's like we're going to trial. I like to stick to just the facts that I can know in terms of what the state is presenting or what the defense is presenting. And at least for the criminal case, things are looking pretty bad. We're looking at a fairly serious felony, assuming, of course, that the state doesn't change it to be even more serious based on the testing. So I don't know what time limits they have there in Minnesota, but at least in principle, they could amend these charges to bring additional charges based on the additional drugs they found and potentially even more serious charges than they brought initially, depending on the details. So there's the possibilities are only downhill.
Yeah. It's so let's go into the ruling and because we know you guys like the documents. Let's go. Omnibus. So this is the judge's ruling. The above. Now, just so everybody understands, there was one judge assigned the Nick's case. Nick asked for that judge to recuse herself. She recused. So there's another judge who is not involved with Nick's civil case. So now it's a totally different judge who's been on there since August 21st, 2024, and he's evaluating this. Defendant Nicholas Robert Ricada appeared. It was represented by Francis White, attorney at law, state of Minnesota, appeared through Kirsten Pierce and Jordan Engler, assistant Candy, Ojai County attorney. So that's where we're at. So go ahead, Kurt.
Defendant's charged with 3 counts. Second-degree controlled substance, although as we pointed out before, that was kind of on the borderline. The threshold for second degree is 25 grams, and he was found with 26 grams and change, including packaging. So there's still the possibility that could be lowered down to third degree at some time, although there's also the possibility of additional second degree or other charges based on other drugs, so that might change in the future. Possession of firearm by an ineligible person. He had a gun, owned a gun at the same time. He's a user, which is a gross misdemeanor, and child endangerment, which in this case was, I believe, just the mere fact that the children were present at a place in which drugs also were present. So the child endangerment was the very fact that children was there and not more. I make this point because obviously child endangerment comes in different degrees of concern, and at least in my mind, that would be on the lower end of the degrees of concern when you're talking about child endangerment.
Yeah, this is kind of just tangentially, like he had the coke, he got the guns, you got kids there. It just all kind of wraps up together. But I want to make it very clear for all of you out there who may think that Nick is pretty much is done. Like we all said, if that search warrant is not tossed, he's done.
It's a 2-witness case for the state.
So
it's a 2-witness case. You call the cop to the stand and you say, "Were you there that day?" "You surely were." "Were you wearing a body cam?" "Yes, I was." "Great. Let's roll through that footage frame by frame and discuss all the things you saw and observed. Is this you holding the bag of the drugs?" "It sure is." "Thank you, officer." Second witness. "Hey, lab tech, did you do a test?" "I sure did." "What'd you find?" "They're drugs." "Great. No further witnesses." Anything beyond that is bonus.
Yeah.
So it's a 2-witness case, and then you throw in additional stuff if you have time.
Yeah, I think at this point, I think he's done. So we have the 3 main charges, and it doesn't look good. So the defendant seeks a Frank's hearing and contests the seizure of the firearms, which we're going to go into. And the judge in this particular thing goes through all the evidence that was essentially found with Nick. So here are the fact findings.
Ruling. So the judge is the fact finder on the issue of probable cause. For that purpose, of course, on the issue of liability, which is to say guilt, the finder of fact would be the jury. But these are findings of fact by the finder of fact, the judge. So these are facts now, for at least the purposes of this exercise. So on May 22nd, Quinn Pomplin of Candy, Ohio Sheriff submitted an application for the search warrant regarding the premises. The address subject to the search warrant was known to the deputy to be defendant's residence. The search warrant was for controlled substances prohibited by law, paraphernalia commonly associated with sale or use, and items that show controlled substance use are not legal drug paraphernalia. The search warrant was signed by the district court. The search warrant application states that on May 16th, Candy, Ohio County Sheriff Officer Dave Nestor received a report of possible child neglect and controlled substance involving the use of the defendant and his minor children.
Now, I think it's important that while Kurt is reading is understanding this, the judge is laying out all the evidence they have for probable cause.
Right.
So all of this is the probable cause. So this is going to be lengthy because they're saying this is what led to probable cause. So removing one of these things doesn't destroy your probable cause because you still have all this. So the judge is being very thorough in saying this is why we have probable cause for the search warrant.
Yeah, much like trial too. You don't, how much of the puzzle do you need before you can say guilty, for example? It's not 100%. Proof beyond a reasonable doubt isn't that. So it's like, well, how much of the picture do you need? And removing one piece doesn't necessarily throw you below the threshold. It's the very odd trial where there isn't some sort of evidence that goes the other way.
That's
right.
Yeah.
There's usually something that goes the other way. So removing one piece from the equation isn't enough, and it certainly isn't enough when you have probable cause as a low standard.
Yeah.
In this case, Deputy Pomplin reviewed social media videos. Deputy Pomplin notes the defendant's appearance in the videos changed from January to May. His changes in appearance are noted as common with controlled substance users. Deputy reviewed Aaron Imholt's social media videos. Imholt hosts his own social media video program in which he commits crimes while on air. From watching Imholt's videos, it's apparent that the defendant and Imholt previously had a friendship and has since had a falling out. That is definitely one way to describe it.
Yeah.
Imholt states in his videos that he recently experienced with Jane and Molly, which is uppercase. I didn't know Molly got a proper name. I'm sure she'll be thrilled. On May the 22nd of 2024, Imholt uploaded a video where he spoke about defendant and insinuated that defendant was using controlled substance. During Imholt's May 22nd video, he referenced a video posted by defendant on May 21st. Imholt notes that white powdery substances can be seen on the defendant's nose during the defendant's May 21st, 2024 video. The nose was not made out of coal, nor was the nose red like Rudolph Red-Nosed Reindeer.
Yeah.
This was a white nose.
White,
not black, not red, white.
But also, too, just so everybody understands, the cops don't have to prove beyond a shadow of a doubt that there are drugs in that house. It's just, is it reasonable to suspect that a search would find that there would be drugs there, right, based on the information we have, and that's what this is all alluding to. They don't have to say I have somebody who saw the coke and using the coke in the house, but it's better to have that. But now they're using all the circumstantial, because again, this is a circumstantial thing. Other circumstances that would allow someone to understand that they would find this contraband in his house. I'm talking like contraband. I'm talking like a cop now.
Defendant's May 21st video was removed from the internet. Deputy Pomplin was able to review defendant's May 21st video. Defendant's May 21st video is 4 hours and 4 minutes in length. At approximately 2 hours and I don't know if that's 2 hours or 2 minutes. At 2:46, I'll just read it's written.
Here's what we're going to do, guys. I'm going to go to the bathroom. I'm muted. This is how streaming should be. Everybody's mad if you stream drunk. You're the one person who's not mad ever on the internet is Medicare.
Defendant leaves the video to use the restroom. Upon return at approximately 2:40, so that's 2 hours 46, defendant appears with a white powdery substance on his nose. Defendant's demeanor is excited. At one point, closes one eye to be able to read the screen, rambles, and slurs his speech. We've seen the clips.
Yes.
Defendant Pomplin was previously a drug recognition evaluator based on Detective or Deputy Pomplin's training and experience, which are the magic words the cops love to use.
Yeah.
Defendant's behavior in the May 21st, 2024 video indicates a poly, which is multiple substance abuse, which may or may not be the only poly thing that Nick is familiar with.
Uh-oh.
Deputy Pomplin notes defendant's behavior is consistent with using both central nervous system stimulants and depressants. Deputy Pomplin's summaries of Imholt's May 22nd video and defendant's May 21st video are accurate. That's a conclusion of fact I'd just like to make clear once again for the record. The judge is saying the summary is accurate. That's a conclusion of fact. That's a fact now. Moving on. There is no indication that law enforcement viewed an altered or edited version of defendant's May 21st video, even if it was not the original.
So remember that was Nick's big argument, that it's not the original video. It's not the original video. The cop lied, and the new video has this what is it? The watermark on it.
Yes, from backwards internet.
Yeah, but the judge is saying if the two videos are the same, it doesn't really matter. It doesn't really matter. So,
all right, the information contained within the search warrant was accurate and reliable for the reviewing judge. There were no clear false statements, significant material omissions, or material misrepresentations that caused the search warrant to be false, misleading, or in violation. Again, that is a finding of fact. All facts contained in the memorandum of the court are incorporated by reference as findings of fact. They are findings of fact.